good morning or indeed good evening. This is part of the Inner Temple advocacy training for new practitioners, and what we're going to focus on today is case theory. My name is Tom Kark. I'm a member of the Inner Temple and I'm a teacher trainer with them. I'm a criminal practitioner. I've been practicing for about 35 years, prosecuting and defending, and I also sit as a Crown Court recorder all over London and at the Old Bailey. And with me is Graham Aldous.
Hi, I'm Graham Aldous. I'm a civil practitioner. My main work is catastrophic injury claims, but I've sat in crime as a judge and I've done crime as an advocate back in the day. But this session isn't going to be about civil or criminal, it's going to be about case analysis for any case, and it's to recap on the principles involved in case analysis.
So I'm going to do a very short introduction and then hand over to Graham. But he needs to change the slides. Thank you very much. All right, so what is case theory and why do we need it? Well, the case theory is your map of the case. It's the blueprint. And it's much like starting a journey. If you don't start off with a sat-nav or even a map, you are not going to know where you want to get to. It is absolutely critical to have prepared your case theory well in advance of starting the case. What is the case theory? It's the version of the facts that you are going to ask the court to accept, which is going to lead to a successful outcome for your client. And we'll go into the constituent parts of it. It's got to be credible, and that means it's got to be based upon the evidence. So it's got to be founded upon the evidence that you know that you are going to be able to adduce. And of course it's got to be internally consistent. It's got to be thought through from A through to Z. Why is it so important? It's because it's going to guide every single question that you ask in the case. If you are a prosecutor, it's going to guide you as to the witnesses that you have to call. If you're defending, it's going to be your blueprint for your cross-examination. If you find yourself asking a question outside of your case theory, it's almost certainly an unnecessary one. And that point when the judge intervenes and says, well, where are we going with this, means almost certainly that you have either not prepared your case theory or you've departed from your case theory. You've got to understand every aspect of your case theory in real detail. Obviously you've got to know what you want to try to persuade the tribunal of by the end of the case, but that means you've got to have asked yourself in fine detail all of the questions that you think your tribunal might be asking. So it's, as Graham will look at later on, it's asking those why questions, thinking about it, bath, shower, thinking about it in bed over breakfast, whenever you do, you've got to think through all of the possible permutations of your case and each part of it. What's the danger if you haven't prepared your case theory? You'll end up with a rubbish speech because you won't have adduced the evidence that you need, or you will have adduced evidence in error that you possibly don't need. You won't have called the witnesses that you needed to produce the foundation for the excellent speech that you want to make at the end of the case. So from beginning to end, it is case theory all the way. And that means you will have written your speech, of course, before you ask your first question. I'm going to hand over to Graham.
So what do you need to turn that into practice? What you need mainly is curiosity. You need to be curious about why your case makes sense, why your client is saying what they're saying. You need to be curious about why the other side's case doesn't make sense, Why are they saying what they're saying? What's the explanation for it? You need to ask all those why questions. And when you've done all the why question asking, then you're ready to go into court with a solid case theory. And what does the case theory give you? If you've got a solid case narrative and a very solid idea of it in your mind, it will inform you as to what questions you need to ask, what questions you shouldn't ask, what questions you need to put to challenge the other side's evidence, and the answer to the tricky questions that the judge might bowl at you during the case. So at each step of the case, a solid core case theory will prove its worth because it will give you the answers and it will make your life an awful lot easier. It's not about making your job harder, it's about making your job easier. Where do we find guidance on what it is that judges want from you as an advocate in this form of case analysis? The book I recommend is Tom Bingham's The Business of Judging, and he particularly has a chapter on the judge's juror, which deals with how judges and juries analyse evidence for credibility. And what Tom Bingham identified was consistency with agreed or clear evidence. So that if there isn't an issue about something and your client's evidence is consistent with clear or agreed evidence, that's something that gives it credibility. Internal inconsistency, as Tom was saying earlier, judges and juries look for whether someone is all over the shop in their evidence, saying one thing one moment and another thing another, or whether their evidence is internally consistent, and whether the case theory behind it is internally consistent. Consistency with prior statements. There's a lot of written now about why people may give evidence that's inconsistent with what they've said before, and there are good reasons why people may differ from their earlier statements. But as an advocate, the truth is that judges and juries will look to see whether there is inconsistency with a prior statement. And if there's an inconsistency which you need to deal with, then you need to work out as part of your case theory what the explanation for that inconsistency is. And part of the joy of being an advocate is to come up with the reasons to explain to the court why all the inconsistencies in your client's evidence are evidence of your client's truth and honesty, whereas all the inconsistencies in the other side's evidence are evidence of their unreliability and their dishonesty, if needs be. Then he identified credit in relation to other matters. What did he mean by that? Well, if you can show that somebody has lied in relation to some other issue and has convictions for dishonesty in another setting, then that may impact on the credibility of the evidence that your client is giving now or your witnesses are giving now. So that's evidence in relation to some other matters that undermines the evidence that's currently being given. And then finally, right at the bottom, Tom Bingham identified demeanour. And when we're doing judicial training, we're at pains to explain to the judiciary that demeanour is an unreliable way of assessing a witness. It's not good enough for a judge simply to say, when I looked at the witness, I thought they were telling the truth and therefore I believe them. Their reasoning's got to be rather more solid than that. But as an advocate, it's dangerous to ignore demeanour. Although Tom Bingham thought that demeanour was really hardly something to put on the list at all, the reality is that judges and juries do look at demeanour and do assess the performance in the witness box. And so you need to think about it as an advocate as to how you use that to your advantage or how you explain it away and justify perhaps a difficulty on demeanour in the witness box. And where does that leave you for your case analysis? Well, it gives you a kind of hierarchy of evidence to think about in terms of how you're going to present your case. Now, this is not a set menu on the order in which you will deal with things in your closing submissions, but top of the hierarchy comes common ground. Common ground gives a jury a solid basis from which to work, and it means for a judge that it's an easy win. The judge doesn't have to apply any effort, they can't be appealed for relying on common ground. Similarly, admissions by the other side. Much more convincing than your client's statement of a fact is the other side's statement of the same fact. So an admission by the other side carries more weight than simply an assertion by a witness on your side. Independent evidence, if it's really valid evidence and it's truly independent, then judges and jurors like that as a way of assessing whether a partial witness is to be believed or not. Contemporaneous evidence, as with inconsistency with prior statements, there may be lots of reasons why the evidence now differs from contemporaneous evidence. If your evidence is different from contemporaneous evidence, it's something you're going to have to explain. If the other side's evidence is different from their contemporaneous evidence, it's probably something you're going to want to rely on as showing that their evidence now is unreliable. Physical features and natural inferences, that may move up and down the hierarchy depending on the circumstances of the case. But if a witness's evidence is consistent with the physical layout of the scene, then that may help establish its credibility. If it's inconsistent with the scene, if they could only have seen something by seeing through a wall so that their evidence is impossible, that affects the credibility of their evidence, and it's the sort of point that you're going to be wanting to make in your closing submission. And then right down at the bottom comes what your client says. It's so tempting as an advocate to say, my client says X, and it must be true. But actually that's the least persuasive form of advocacy. Of course you will be relying on what your client says, but the way you will be adding value, the way you will be bolstering it, is by reference to all these other points to support your case and to undermine the other side's case.
Can I add one thing on physical features and natural inferences, particularly for the criminal advocate? When you can, don't rely on photographs, go to the scene. I'm sure some of you will have done this already, but in any serious crime, going to the scene where it happened is so often revealing. In a way that photographs, even the modern technology, 360-degree videos, etc., that the police use, it's not as good as going there. Second point is always look at your exhibits. Never allow an exhibit to come out of the bag in front of the jury that you haven't looked at first. It will go wrong if you do. So I'll hand back to Graham.
Now, on the new practitioners course, we're going to be looking at expert evidence and working out how to tackle experts. So how does any of that feed into dealing with expert evidence? Well, in the case of Kennedy and Cordier, the Supreme Court approved a quote from Dingley and Chief Constable, a quote of Lord Prosser, who said, "As with judicial or other opinions, what carries weight is the reasoning and not the conclusion." And so it's the reasoning that you want to be looking at and to see how that's going to bolster your case or whether it's something you can undermine in the other side's case. So we're dealing with people who are held out as independent experts, and you should go right back to basics. Are they actually experts? If they are experts in the field that actually matters, in the particular point in issue that actually matters? Are they truly independent? They might not know any of the parties, but are they showing a bias to one side or the other? Are they indicating that they have accepted one side's version of facts rather than the other side's version of the facts? Are they indicating perhaps that they are rather over-aware of who's paying the bill? What is their reasoning? How have they come to the conclusion that they have? Have they given a justification for it? If they've given a justification, if they've built up some reasoning, are any of those points that you can knock out and therefore their reasoning falls? What assumptions have they made? Why are they making assumptions at all if there's evidence that could have been obtained? And if they are making assumptions, are they only making assumptions in favour of one side rather than the other? If they are, why are they doing that? And what do any assumptions that they made, what does that tell you about their reasoning and about their impartiality and indeed perhaps about their expertise?
And a very quick word from me on the first two. Look out for the expert who goes beyond their expertise. And it happens very often when they get a little bit too excited and they're trying to help their own side out. Because if you find an expert has gone beyond their expertise, it's happened to me in a case I have just finished, you're then able to question their independence. Why have they been prepared to go outside their expertise and try to help the other side a bit too much? And if you damage their independence, then you damage their credibility, which is really fundamental. So always look for that and never encourage your own expert to go outside their own expertise, otherwise the other side is going to do the same thing to you.
So as with factual evidence, dealing with expert evidence is all about asking the why questions and not being afraid to ask the why questions. Why is your expert saying what they're saying? Why does it make sense? Why are the other side saying that it's wrong? Why are the other side, is the other side's evidence saying something different? And when you've answered all those why questions, then you'll be ready to deal with the evidence. And expert evidence can add a layer of complexity to a case. And when you first read an expert report in an area that you're unfamiliar with, it might seem rather scary as being complex. But your job is not to take that complexity and make your case complex. Your job is to cut through that complexity and make it simple. You should ask the why questions. You should ask the dumb questions, as they might sound. But if you don't understand it, you can't present it, then you won't be able to persuade somebody else to accept it. So, as with all advocacy, it's not about making a simple case complex. It's about taking a case, however complex it might be, and making it simple. Because judges and juries will like simple cases, and if you've got a simple case that makes sense, they're more likely to accept it.